efficient breach. Now let's talk about why courts prefer expectation damages, and we'll use the theory of efficient breach. Let's assume that Evan agreed to sell and Francis agreed to buy a certain car for $10,000. At the time of the contract, Evan, the seller, must believe that the car, he's selling the car, so he must believe it's worth less than $10,000. Why else would he sell the car? You're not going to sell something for more than it's worth, right? You're going to sell it for, because you believe, you're going to sell something for more than it's worth, because otherwise you'd want to keep it. And so Frances, on the other hand, she must believe the car is worth more than $10,000, or she wouldn't be buying it for $10,000. So we have some assumptions baked into this price. Right? If the parties don't have different values on the item, why would they buy or sell it? So let's further assume that Evan values the car at $9,000 and Frances values the car at $11,000. Why might two people value the same thing differently? Well, one is just a matter of opinion, but different people are in different positions. Some people need to drive to work. Some people can walk to work. The value that they place on a vehicle can be different depending on what their needs are. So if the car is to be sold for $10,000 and Evan values it at $9,000 and Frances values it for $11,000, if nothing changes, then Evan will sell and Frances will buy the car and they'll go away happy. But this is contracts class, so no one ever goes away happy, right? We're in remedies here. Obviously things did not go so well. What might go wrong? Well, maybe between the time of the contract and the time the contract needs to be performed, Evan's value of the car increased. This could happen for many reasons. For example, the market price of that used car could go up because it got a good rating from Consumer Reports. This is a systemic change in value that would affect everybody. Or Evan might get a new job outside the city, and now he needs the car for the commute. This is an idiosyncratic change in value, unique to Evan. In the first case, Evan would now be willing to sell the car for $12,000 because that's what he can get on the market. In the second case, Evan would prefer to keep the car for himself unless he can get $12,000 because that's how much he values having a car. In either case, he no longer wants to sell the car to Frances for $10,000. Whether Evan will sell the car to Frances or not, however, depends on how we measure damages in the case of a breach. Likewise, what about Frances? What if she no longer wants to pay for the car when performance is due? This could happen for many reasons as well. For example, the price of that car may have gone down because a new model was just released. Or Frances may have gotten a new job that's walking distance from her house, and she no longer needs the car for the commute. In any event, Frances now only values the car at $8,000, and she doesn't want to pay $10,000 for it. Will she breach? Again, this depends on the measure of damages that will have to be paid in the case of breach. We should remember that there are many ways we could calculate damages. We don't have to use expectation damages. We're trying to understand why expectation damages creates the best state of the world. Instead of expectation damages, for example, courts could award reliance damages, which would rewind the agreement and put the party in the position they would have been if the contract was never made. The court could award nominal damages, a symbolic amount, usually $1, which signifies there is a breach, but with minimal, basically no actual damages. The court could punish the breaching party, really discouraging breach by having a large amount that has to be paid, and that is meant to punish and therefore to discourage breach. So how will these regimes affect what Evan and Frances do, and which results in the best state of the world? If damages are nominal, Evan and Frances will obviously breach. Evan will be happy to pay $1 if that means he ends up with a car worth $12,000 that he would otherwise sell for $10,000. Under nominal damages, he effectively has a choice of getting $10,000 in cash or a car worth $12,000 minus $1 in damages. We can see that Evan will rationally choose the option where he gets, in this case, $1,999 more dollars. Most of us would make that rational choice. Frances would make the same calculation. So if nominal damages are a usual approach, promisors will always breach when something better comes along. This makes contracts highly uncertain. So parties will not bother to make them in the first place. The uncertainty as to whether contracts will be performed is even worse. And so nominal damages cannot be the best measure of damages in the ordinary course of contracts. How about punitive damages? That would really make sure we don't breach. Evan and Francis will not breach if damages are punitive so long as they're high enough. Let's imagine a rule that a breaching party has to pay 10 times the contract price as punishment for breaching. That would reflect a societal view that breaching is bad. But does it reach the right result for the economy? If Evan has a choice of selling a car worth $12,000 for $10,000 at a loss of $2,000 effectively, or keeping the car and paying damages of $100,000, he will rationally sell the car and take a $2,000 loss instead of a $100,000 loss. At first blush, this may seem like a good result because it guarantees contracts will be carried out. But there is a deeper problem. To understand the problem, we need to have a little more discussion about the fundamental principles of contract law in the first place. Contract law facilitates the transfer of property to the party who values it most. It does this in many ways. For example, consider the doctrine of consideration, right? Which states that a contract must be the product of a bargain for exchange. Why do we have a requirement that contracts have to be the product of a bargain for exchange? Why do we need consideration? Because when people bargain for an exchange, we assume they do so to make themselves better off, just as we saw here. The people who entered into the deal to buy the car for $10,000, the seller believed it was worth less than $10,000, the buyer believed it was worth more than $10,000, and the fact that they were each getting something out of the bargain means that we can assume that every bargain struck, people think they're going to be better off. So contract law is premised on voluntary transactions, which reallocate property to the person who values it most. How do damages achieve this purpose? Damages support the purpose of reallocating property to its place of highest value by requiring that parties get the benefit of the bargain that they struck. This purpose is not supported by any measure of damages that gives parties more or less than what they bargained for. Expectation damages are therefore the most efficient because they allocate resources to the parties who value it most, even if things change after the contract is signed. So let's return to the example of Evan and Francis, who agreed to buy and sell a car for $10,000. And let's assume the value of the car to Evan increased by $2,000. Now Evan values this car at $12,000, and he no longer wants to sell it for $10,000. Under expectation damages, if Evan refuses to sell the car, he has to pay Francis $1,000. Why? Because Francis valued it at $11,000, and she was going to get it for $10,000. And so she was going to be $1,000 better off as a result of the bargain. And so if we give her $1,000 instead of the car and take her $11,000, financially she's just as well off. She can now take that $11,000 and buy a different car that she likes just as much. Meanwhile, if Evan gets to keep a car worth $12,000 and pay $1,000, he's $1,000 better off than if he fulfills the contract. Why? Because if he fulfills the contract, he effectively loses $2,000 because he sold something worth $12,000 for $10,000. So he's $2,000 worse off, and now he's only having to pay $1,000. So by applying expectation damages, Francis benefits $1,000, Evan is harmed $1,000, and the parties are better off than if Evan is harmed $2,000. The net social welfare of this transaction is greater. And so actually the world is better off if Evan breaches, because now the party who values the car the most keeps it, and the other party is just as well off as if the bargain were struck. There is more value in society because of the breach by $1,000. This is called the efficient breach hypothesis, and it does have some limitations. First, breach usually means going to court, which is costly, and so this is not a frictionless transaction. Second, if parties can renegotiate their contracts, they would simply renegotiate for a different price instead of breaching, but it may not be that easy to renegotiate a contract. Third, if one party might breach, the other party may not make investments in reliance of the contract. If you don't know if the contract will be performed, you may be hesitant to, for example, build a carport to put the car in, because even though you have a contract, you don't know that you will get it. There are other reasons why the efficient breach theory may not be right, but to date, I have not heard a better theory as to why we should use a certain type of damages, and therefore expectation damages seems to be the best measure of damages in contract law. That was the efficient breach theory. Before we move on to alternatives to expectation damages and how to apply them, are any questions about the theory of efficient breach?